The Virginia eviction notice. What is an eviction notice? Eviction notice, or notice to quit, is a letter sent by the landlord to the tenant notifying them that they should either take or stop a certain action or vacate the rented premises. Eviction notice can be of two types: conditional, when a tenant is given time to remedy the breach of the lease, or unconditional, when a landlord terminates the lease without any alternative options for a tenant. What should an eviction notice include? Information about the tenant and the landlord. The reason for sending the notice. The date by which the tenant should take or stop a certain action. The consequences of non-compliance. The date and way of notice delivery, and the landlord's signature in the form of certificate of service attached to the notice. How to evict a tenant in Virginia. Non-payment notice. Tenancy at will, which is tenancy without a written agreement or end date in Virginia, requires the landlord to set a grace period of 5 days from the beginning of the month. For written tenancies, grace periods should be addressed in a lease agreement. When the tenant fails to pay rent when it is due, the Virginia law requires the landlord to send the tenant a 5-day notice to pay or quit before starting an eviction process. Non-compliance notice. If the tenant violates other lease terms and the violation is curable, they should get a 30-day notice that would give them 21 days to correct the issue. If the violation is considered non-curable, the landlord should provide the tenant with a 30-day notice to quit, not giving them a chance to correct the issue. If the tenant participated in illegal activity, the landlord doesn't have to send any prior notice to them according to the state law. What if the tenant fails to comply? If the tenant fails to comply with the rules of the lease and landlord's requests, the landlord can file a complaint with the appropriate Virginia circuit or district court. The fee will depend on the court and county. The tenant should get the summons and complaint within 10 days before the hearing by a person authorized by court. The tenant's failure to appear for the hearing might result in a judgment in favor of the landlord by default. If the landlord wins the case, the court will issue the writ of eviction. Then, the sheriff or constable will have from 15 to 30 days to deliver in person or post a writ on the rental property, giving the tenant 72 hours to move out.